Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Garland v. Gonzalez. In this case, the court considered this issue: is a non-citizen who has spent more than 6 months in immigration detention awaiting resolution of their deportation withholding claim entitled to a hearing before an immigration judge to determine whether they can be released on bond? The case was decided on June 13, 2022. The court held that Section 1252 F1 of the INA deprived the district courts of jurisdiction to entertain respondents' requests for class-wide injunctive relief. Justice Alito delivered the opinion of the court, in which Chief Justice Roberts along with Justices Thomas, Gorsuch, Kavanaugh, and Barrett joined. Justice Sotomayor filed an opinion concurring in the judgment in part and dissenting in part, in which Justice Kagan joined, and in which Justice Breyer joined as to Parts 2A2, 2B2, and 3. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Alito delivered the opinion of the court. Respondents in these two cases are aliens who were detained by the federal government pursuant to 8 U.S.C. Section 1231A, 6, pending removal from this country. Respondents sued in 2 federal district courts, alleging that Section 1231A, 6, requires the government to provide bond hearings in cases like theirs. Both district court certified classes agreed with respondents' claims on the merits and entered class-wide injunctive relief. The Ninth Circuit affirmed both judgments in relevant part. We granted certiorari and instructed the parties to address whether another provision of the Immigration and Nationality Act deprived the district courts of jurisdiction to entertain respondents' requests for class-wide injunctive relief. We hold that the statute has that effect, and we therefore reverse. The 2 cases before us arise out of respondents' detention pursuant to Section 1231A, 6, which gives the federal government discretionary authority in specified circumstances to detain aliens who have been ordered removed from the United States. Respondents Esteban Aleman Gonzalez and Jose Eduardo Gutierrez Sanchez, the named plaintiffs in the case that bears Aleman Gonzalez's name, are natives and citizens of Mexico. They each re-entered the United States illegally after being removed, and after they were apprehended, their prior orders of removal were reinstated as authorized by Section 1231A, 5. They sought withholding of removal on the ground that they would be subject to torture or persecution if they were returned to Mexico. While they awaited proceedings before an immigration judge, they were detained under Section 1231A, 6, and they then filed a putative class action in the United States District Court for the Northern District of California, alleging that aliens detained under Section 1231A, 6, are entitled to bond hearings after 6 months detention. The district court certified a class of similarly situated plaintiffs and enjoined the government from detaining respondents and the class members pursuant to Section 1231A, 6, for more than 180 days without providing each a bond hearing. A divided panel of the Ninth Circuit affirmed. Respondent Edwin Flores Tejada, the named plaintiff in the case that bears his name, is a native and citizen of El Salvador. He likewise was previously ordered removed, re-entered the country illegally, had his prior removal order reinstated, applied for withholding of removal, and was detained under Section 1231A, 6. He filed suit in the Western District of Washington, likewise alleging, as relevant here, that Section 1231A, 6, entitled him to a bond hearing. The district court certified a class, granted partial summary judgment against the government, and entered class-wide injunctive relief. A divided panel of the Ninth Circuit affirmed in relevant part. The government petitioned for certiorari and asked us to decide whether an alien detained under Section 1231A, 6, is entitled to a bond hearing. We granted that petition and instructed the parties to address the threshold question whether the district courts had jurisdiction to entertain respondents' requests for class-wide injunctive relief. We hold that the district courts exceeded their jurisdiction in awarding such relief. We begin with the text of Section 1252 F1, which provides: regardless of the nature of the action or claim or of the identity of the party or parties bringing the action, no court, other than the Supreme Court, shall have jurisdiction or authority to enjoin or restrain the operation of the provisions of Part 4 of this subchapter, as amended by the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, other than with respect to the application of such provisions to an individual alien against whom proceedings under such part have been initiated. With one exception that we will discuss momentarily, the critical language in this provision strips lower courts of jurisdiction or authority to enjoin or restrain the operation of the relevant statutory provisions. The ordinary meaning of these terms bars the class-wide relief awarded by the 2 district courts. The term to enjoin ordinarily means to require, command, or positively direct an action or to require a person to perform, or to abstain or desist from, some act. When a court enjoins conduct, it issues an injunction, which is a judicial order that tells someone what to do or not to do. The term to restrain means to check, hold back, or prevent, a person or thing, from some course of action. We have suggested in another context that restrain sometimes has a broad meaning that refers to judicial orders that inhibit particular actions, and at other times it has a narrower meaning that includes orders that stop, or perhaps compel, such acts. The object of the verbs enjoin or restrain is the operation of certain provisions of federal immigration law. The operation of a thing means the functioning of or working of that thing. The way in which laws ordinarily work or function is through the actions of officials or other persons who implement them. This is certainly true of the statutes to which Section 1252 F1 refers, i.e., the provisions of Part 4 of Subchapter 2 of the Immigration and Nationality Act. Those provisions charge the federal government with the implementation and enforcement of the immigration laws governing the inspection, apprehension, examination, and removal of aliens. Accordingly, the operation of the relevant statutes is best understood to refer to the government's efforts to enforce or implement them. As the government put it at oral argument, the operation of the provisions is a reference not just to the statute itself but to the way that it is being carried out. Putting these terms together, Section 1252 F1 generally prohibits lower courts from entering injunctions that order federal officials to take or to refrain from taking actions to enforce, implement, or otherwise carry out the specified statutory provisions. Section 1252 F1 includes one exception to this general prohibition. The lower courts retain the authority to enjoin or restrain the operation of the relevant statutory provisions with respect to the application of such provisions to an individual alien against whom proceedings under such part have been initiated. The court has already commented on the meaning of this exception. In Reno v. American Arab Anti-Discrimination Committee, we wrote that Section 1252 F1 prohibits federal courts from granting class-wide injunctive relief but does not extend to individual cases. This interpretation follows from the statutory text. In framing the exception to the general ban on injunctive relief, Congress used the phrase an individual alien. It thus employed a singular noun, an alien, modified by an adjective, individual, that means pertaining or belonging to, or characteristic, of one single person. Therefore, Section 1252 F1 does not preclude a court from entering injunctive relief on behalf of a particular alien, so long as proceedings against the alien have been initiated, but injunctive relief on behalf of an entire class of aliens is not allowed because it is not limited to remedying the unlawful application of the relevant statutes to an individual alien. On this interpretation of Section 1252 F1, the injunctions entered by the district courts in these cases were barred. The respondents in both cases were detained pursuant to Section 1231A(6), and no one disputes that Section 1231A(6) is among the provisions the operation of which cannot be enjoined or restrained under Section 1252 F1. Both district courts entered injunctions requiring the government to provide bond hearings not only for respondents but also for all other class members. Those orders enjoin or restrain the operation of Section 1231A(6) because they require officials to take actions that, in the government's view, are not required by Section 1231A(6), and to refrain from actions that, again in the government's view, are allowed by Section 1231A(6). Those injunctions thus interfere with the government's efforts to operate Section 1231A(6), and the injunctions do not fall within the exception for individualized relief because the injunctions were entered on behalf of entire classes of aliens. Respondents advance two counterarguments, but both fail. Respondents first contend that the operation of the covered immigration provisions means the operation of those provisions as properly interpreted and that what Section 1252 F1 bars are class-wide injunctions that prohibit the government from doing what the statute allows or commands. We do not think that this is the most natural interpretation of the term operation, since it is very common to refer to the unlawful or improper operation of whatever it is that is being operated. If cars, trucks, railroads, water utilities, drainage ditches, auto dealerships, planes, radios, video poker machines, cable TV systems, and many other things can be unlawfully or improperly operated, it is not apparent why the same cannot be said of a statute. Thus, the ordinary meaning of the language of Section 1252 F1 weighs against respondents' interpretation. Apart from ordinary meaning, the statutory context provides three additional reasons to reject respondents' reading. First, respondents' interpretation, which makes the reach of Section 1252 F1 depend on the nature of the claim in question, clashes with Section 1252 F1's prefatory clause, which states that the bar applies regardless of the nature of the action or claim. Second, Respondent's interpretation would limit Section 1252 F1's restriction to a most unlikely set of claims. With perhaps a few small exceptions, the only claims to which Section 1252 F1's prohibition would apply are constitutional claims. But it would be most unusual for Congress to disfavor constitutional claims in this way. And if Congress had wanted to target just constitutional claims, it could have surely made the point more directly. The suggestion that Congress sought to achieve that goal by using the term operation is far-fetched. Third, Respondent's interpretation would make a court's jurisdiction to entertain a request for class-wide injunctive relief dependent upon the merits of the claim. Under Respondent's reading, if a complaint sought class-wide relief on the ground that the government was misinterpreting and misapplying a covered statutory provision, the court would proceed to adjudicate the merits of that claim and might even hold a trial. But if the court ultimately rejected the claim on the merits, that holding would mean that the court never had jurisdiction to grant that request for relief. For all these reasons, Respondent's interpretation of operation must be rejected. Respondents next argue that Section 1252 F1 allows class-wide relief so long as all the class members are individuals who already face the enforcement action. But Section 1252 F1 refers to an individual, not individuals, and as noted, we have stated on more than one occasion that it bars class-wide injunctive relief. Respondents dispute the correctness of these statements and point out that a nearby provision, Section 1252E, 1b, expressly bars the certification of a class under Rule 23 of the Federal Rules of Civil Procedure. Because Section 1252 F1 lacks any express reference to class actions, respondents infer that no preclusion of class-wide relief was intended. We are reluctant to give much weight to this negative inference. It is possible that Section 1252 F1 simply uses different language to bar class-wide injunctive relief and extends no further. But if the provision is not read that way, then the most plausible reading is not that it allows class-wide relief but rather that it permits injunctive relief only with respect to the application of a covered provision to an individual alien against whom proceedings under such part have been initiated. A literal reading of that language could rule out efforts to obtain any injunctive relief that applies to multiple named plaintiffs, or perhaps even rule out injunctive relief in a lawsuit brought by multiple named plaintiffs. The government does not advocate that we adopt such an interpretation, and we have no occasion to do so in these cases. It is sufficient to hold that the class-wide injunctive relief awarded in these cases was unlawful. The judgments of the Court of Appeals are reversed, and the cases are remanded for further proceedings consistent with this opinion. It is so ordered. Justice Sotomayor, with whom Justice Kagan joins, and with whom Justice Breyer joins as to Parts 2A2, 2B2, and 3, concurring in the judgment in part and dissenting in part. The court holds that lower federal courts are powerless to issue class-wide injunctive relief against the executive branch's violation of non-citizens' rights under several provisions of the Immigration and Nationality Act, INA. It reaches this conclusion in a purportedly textualist opinion that, in truth, elevates piecemeal dictionary definitions and policy concerns over plain meaning and context. I respectfully dissent from the court's blinkered analysis, which will leave many vulnerable non-citizens unable to protect their rights. Respondents in these two cases are named plaintiffs in two class actions, Esteban Aleman Gonzalez and Jose Eduardo Gutierrez Sanchez in the Aleman Gonzalez litigation, and Edwin Omar Flores Tejada in the Flores Tejada litigation. Respondents sought withholding of removal under the INA based on their fear that, if returned to their countries of origin, they would face persecution or torture. The government detained them pending their proceedings, a detention this court has held authorized by 8 U.S.C. Section 1231. In both cases, respondents raised statutory and constitutional challenges to their prolonged detention without bond hearings. In both cases, respondents moved to certify classes of similarly situated individuals. In Aleman Gonzalez, the district court certified a class of all individuals who are detained pursuant to 8 U.S.C. Section 1231a, 6, in the Ninth Circuit, and who have reached or will reach 6 months in detention, and have been or will be denied a prolonged detention bond hearing before an immigration judge. In Flores Tejada, the district court certified a class of all individuals who, 1, were placed in withholding-only proceedings, in the Western District of Washington, and, 2, have been detained for 180 days, a, without a custody hearing or, b, since receiving a custody hearing. By these definitions, the specified classes include only individuals against whom the government has initiated removal proceedings. Both district courts held that Section 1231a, 6, did not authorize prolonged detention exceeding 6 months without bond hearings. Both district courts issued class-wide injunctive relief, preliminary in Aleman Gonzalez and permanent in Flores Tejada, requiring individualized bond hearings. The Ninth Circuit affirmed in relevant part. When the government petitioned for certiorari, it challenged only the lower court's interpretations of Section 1231A(6) as requiring bond hearings after 6 months of detention. The court granted certiorari on the question presented by the government in these cases and a companion case from the Third Circuit. The court additionally directed the parties in these cases to brief and argue the following question: whether, under 8 U.S.C. Section 1252 F.1, the courts below had jurisdiction to grant class-wide injunctive relief. As to that question, the court now holds that Section 1252 F.1 barred the lower courts from granting such relief. Section 1252 F.1 sets forth a precise limitation on the lower federal court's jurisdiction to enter injunctive relief in cases involving specified sections of the INA. The provision states, regardless of the nature of the action or claim or of the identity of the party or parties bringing the action, no court, other than the Supreme Court, shall have jurisdiction or authority to enjoin or restrain the operation of Sections 1221 to 1232, as amended by the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, other than with respect to the application of such provisions to an individual alien against whom proceedings under such part have been initiated. Section 1252 F1 includes two operative clauses: a primary clause that strips courts of authority to enjoin or restrain the operation of the specified provisions of the INA, and a saving clause that reserves that authority is applied to a non-citizen against whom proceedings have been initiated. Properly read, both clauses independently preserve the lower court's authority to order class-wide injunctive relief compelling the executive branch to comply with the INA in these cases. The court holds otherwise only by disregarding the language Congress used in Section 1252 F1, itself, elsewhere in Section 1252, and in the INA as a whole. Section 1252 F1's primary clause provides that the lower federal courts may not enjoin or restrain the operation of the specified provisions of the INA. An injunction that compels the executive branch to comply with the specified provisions, or, phrased differently, prohibits the unlawful implementation of the specified provisions, does not enjoin or restrain the operation of those provisions. This is clear as a matter of plain meaning. Starting with the word operation, all agree that the ordinary meaning of operation is functioning or working. An injunction requiring the executive branch to conform its conduct with a statute or to cease statutorily unauthorized conduct does not enjoin or restrain the functioning or working of the statute. That is because unlawful agency action is not a part of the functioning or working of the authorizing statute. The government responds that operation, as used in Section 1252 F1, is synonymous with implementation, which may include either lawful or unlawful implementation. This contention, however, disregards Congress' careful choice of language. Section 1252 F1 says nothing about enjoining or restraining the executive branch's implementation of the law. By contrast, in other subsections of Section 1252 enacted simultaneously with this one, Congress twice expressly limited jurisdiction over challenges to implementation of a statute or order or specified a particular forum for judicial review of such challenges. As this court previously explained when interpreting this very statute, where Congress includes particular language in one section of a statute but omits it in another section, it is generally presumed that Congress acts intentionally and purposely in the disparate inclusion or exclusion. This is particularly true here, where the relevant subsections of Section 1252 were enacted as part of a unified overhaul of judicial review procedures. In addition to Congress' deliberate use of operation, its use of enjoin or restrain in this context is most naturally read to bar only lower court injunctions that stop the operation of a statute, not those that command the executive branch to conform its conduct to the statute. It is true that, depending on the context, the word enjoin may describe a prohibition, abstain or desist from, some act, or an affirmative command, perform, some act. In Section 1252 F1, however, clear textual signals point to the conclusion that enjoin refers to a prohibition on the operation of a statute. First, Congress consistently has used the term enjoin in Title 8 to refer to prohibitions, including in the immediately neighboring and simultaneously enacted subsection, Section 1252 F2. A standard principle of statutory construction provides that identical words and phrases within the same statute should normally be given the same meaning, particularly where, as here, the same term was used in related provisions enacted at the same time. Even beyond Section 1252 itself, every use of enjoin in Title 8 refers to prohibitory injunctions. Moreover, in Section 1252 F1, Specifically, enjoin is paired with the term restrain, which means to check, hold back, or prevent, a person or thing, from some course of action. The company the word keeps, thus cements a prohibitory reading of enjoin. Under this reading, lower courts may not prohibit the operation of the specified statutes, but nothing in Section 1252 F1 prevents them from commanding compliance with the statutes or enjoining unauthorized agency action. Finally, if any ambiguity remains as to the meaning of the primary enjoin or restrain the operation of clause, a long-standing clear statement principle counsels in favor of preserving the lower court's remaining equitable jurisdiction. This court will not construe a statute to displace court's traditional equitable authority absent the clearest command. There can be no doubt that Section 1252 F1 operates to displace equitable authority to an extent. As explained, however, the most natural and contextual reading of the provision's primary clause does not limit federal courts' authority to enjoin or restrain agency action unauthorized by statute, or to compel agency action commanded by a statute. The clause contains nothing approaching the clear command necessary, under centuries of this court's precedents, to displace that authority. Independently of Section 1252 F1's primary clause, the provision's saving clause also operates to preserve the lower federal court's equitable authority here. That clause provides that lower courts may enjoin or restrain the operation of the covered statutory provisions with respect to the application of such provisions to an individual alien against whom proceedings under such part have been initiated. Each beneficiary of the injunctions in these cases is an individual alien against whom removal proceedings have been initiated. Under these circumstances, Section 1252 F1 poses no barrier to class-wide injunctive relief. The government contends that the phrase an individual alien is inconsistent with injunctive relief on a class-wide basis. A class action, however, is a collection of individual claims. Moreover, contextual and historical evidence demonstrates that the enacting Congress would not have prohibited class-wide relief simply by using the word individual. It was well understood when Congress enacted Section 1252 F1, in 1996 that mere use of the word individual would not preclude class-wide adjudication or relief. In Califano, a unanimous court interpreted Section 205G of the Social Security Act, codified at 42 U.S.C. Section 405G, to permit class actions and class-wide relief, even though the statute provided only that any individual could obtain judicial review. The court rejected the government's argument that the word individual required a case-by-case adjudication of claims under Section 205G that is incompatible with class relief. Class relief is consistent with the need for case-by-case adjudication, the court noted, at least so long as the membership of the class is limited to those who meet the requirements of the provision. We normally assume that, when Congress enacts statutes, it is aware of relevant judicial precedent. When Section 1252 F1 was enacted in 1996, that precedent included both Califano and the settled rule, discussed above, that a statute should not be construed to displace a court's equitable authority absent a clear command. Yet Congress provided no such command against all class-wide injunctive relief in Section 1252 F1. Indeed, in other subsections of Section 1252, Congress provided precisely such a clear command. Section 1252E, 1b, enacted simultaneously with Section 1252 F1, explicitly divests federal courts of authority to certify a class under Rule 23 of the Federal Rules of Civil Procedure in certain cases. The enacting Congress thus knew how to preclude class-wide relief and did so in unmistakable terms when that was its intent. In Section 1252 F1, however, it made no mention of class actions or Rule 23. Again, it is generally presumed that Congress acts intentionally and purposely in the disparate inclusion or exclusion of language, particularly where, as here, it enacted the language as part of a unified whole. The government responds that this reading of Section 1252 F1's saving clause renders the word individual superfluous. Sometimes the better overall reading of the statute contains some redundancy, however, as Congress may employ a belt and suspenders approach to ensure its aims are met. Relevant here, parties other than individuals in removal proceedings may bring immigration-related lawsuits. For example, prior to 1996, several organizations brought pre-enforcement challenges to immigration statutes. In recent years, states, too, increasingly have sued on behalf of their own interests. In drafting Section 1252 F1, Congress had every reason to be doubly sure that only individuals in removal proceedings and not other entities would receive injunctive relief restraining the operation of the specified provisions of the INA. Additionally, the government's redundancy concern is particularly unpersuasive because Congress used the adjective individual redundantly in other immigration-related provisions within Title VIII. In sum, The courts below retained their equitable authority to issue class-wide injunctive relief for two independent reasons. First, the relief the district courts issued did not purport to enjoin or restrain the operation of any statute. Rather, the district court sought to enforce a statute and enjoin what they deemed to be unlawful agency action. Second, and in any event, the injunctive relief issued below fell within Section 1252 F1's saving clause because it concerned only the application of provisions of the INA to individual non-citizens in removal proceedings. This interpretation is a reasonable one. Congress' express and particular use of words in Section 1252 F1 protected the specified statutory provisions against restraint by lower court injunctions, but evinced no quarrel with lower courts ensuring that the executive branch complied with the commands in those provisions. In addition, Congress ensured that this goal did not come at the expense of violating the rights of non-citizens in removal proceedings. The court reaches a contrary result only by prioritizing unavailing and largely atextual concerns. Starting with the primary enjoin or restrain the operation of clause, the court accepts the government's argument that the operation of the relevant statutes is best understood to refer to the government's efforts to enforce or implement them. Aside from ignoring Congress' choice to restrict judicial review of implementation in some subsections of Section 1252 but not others, the court misapprehends how statutes operate. No doubt, laws ordinarily work or function through the actions of officials or other persons who implement them. That proposition, however, only holds if those individuals properly implement the relevant statute. An unlawful implementation of a statute is not the working or functioning of the statute at all, it is simply unauthorized. Restraining such action does not interfere with the operation of the statute for purposes of Section 1252 F1. Resisting this result, the court offers a string cite of several inapt uses of operation, none of which concern the operation of legal authority. The court wonders why, if cars, trucks, railroads, water utilities, drainage ditches, auto dealerships, planes, radios, video poker machines, cable TV systems, and many other things can be unlawfully or improperly operated, the same cannot be said of a statute. The answer is obvious: unlike all of those examples, a statute is the law. Officials may implement a statute unlawfully, but a statute does not operate in conflict with itself. The court also agrees with the government that enjoin, as used in Section 1252 F1, necessarily takes on both affirmative and negative connotations, but only by rigidly segmenting each word in the clause, defining each in isolation, and adding those definitions together. Elsewhere, however, this court has cautioned against such a piecemeal approach to statutory interpretation. Moreover, the court pays no mind to Congress' other uses of enjoin in Section 1252 and elsewhere in Title 8 as meaning banning or stopping. The court offers one final purportedly textual basis for its strained reading of the primary clause, that it is the only option consistent with Section 1252 F1's prefatory clause. The prefatory clause, however, does not purport to expand the scope of Section 1252 F1's restriction. It simply makes clear that the restriction must apply to all claims that would otherwise fall within it, without exception. The court closes with two policy arguments. It deems it most unlikely that Congress would enact a statute that disproportionately limits lower courts' authority to issue injunctive relief to remedy constitutional claims, a result it contends would flow from Respondents' reading. This is in large part a problem of the court's own making. As explained, a proper interpretation of Section 1252 F1's saving clause preserves lower courts' authority to issue injunctive relief on constitutional claims, including on a class-wide basis, so long as all plaintiffs are individuals against whom removal proceedings have been initiated. Moreover, even in pre-enforcement challenges brought by entities or by individuals not in removal proceedings, Respondents' reading of Section 1252 F1 does not prohibit injunctive relief exclusively as to constitutional claims, but also as to claims that arise from any statutes external to the covered INA provisions, for example, a claim that a covered provision violates the Religious Freedom Restoration Act. The correct reading of Section 1252 F1 even-handedly protects the specified INA provisions from all such external, pre-enforcement, lower court injunctions, whether on statutory or constitutional grounds, without shielding unlawful agency action inconsistent with the specified provisions. Whatever the court may think of the wisdom of that policy, it is a perfectly plausible one. The court also worries that under this reading of Section 1252 F1, the inquiry as to whether injunctive relief is available may overlap with the merits of a claim that a covered provision has been violated. The court is wrong to find anything unusual about that consequence. Even as to the question of subject matter jurisdiction, as opposed to the remedial authority at issue here, the necessity of touching aspects of the merits is a familiar feature of litigation. Any overlap may be substantial. Under the Federal Tort Claims Act, for instance, all elements of a meritorious claim are also jurisdictional. This concern, too, offers no justification for the court's departure from ordinary meaning or its disregard of clear contextual evidence contrary to its view. The court's arguments in support of its reading of the saving clause fare little better. The court opens with language from past cases suggesting support for its interpretation. None of the cases the court quotes, however, presented or decided the scope of Section 1252 F1's bar on injunctive relief. The court next affords dispositive weight to its class-exclusive view of the word individual in Section 1252 F1. The court distinguishes Califano in a footnote, asserting that Section 1252 F1's saving clause should be construed narrowly because it is an exception to the primary clause. The point, however, is not that the statute interpreted in Califano was identical to Section 1252 F1, but that Califano established that a statute's mere use of the word individual does not suffice to preclude class-wide relief. Moreover, the court overlooks that it is Section 1252 F1's primary clause, which divests lower courts of their traditional equitable authority, that constitutes an exception to the norm. The court ignores the clear statement rule for such displacements of courts' equitable jurisdiction. Califano and the clear statement rule both instruct that Congress would not have done so much so obliquely, particularly when it clearly prohibited class relief in another subsection of the same statute. On the question of Congress' disparate inclusion and exclusion of language in Section 1252 referring to class actions, the court declines to decide what it thinks. Taking one path, it suggests that one should not give much weight to this negative inference. Taking another, the court admits that adhering to its holding might well rule out efforts to obtain any injunctive relief that applies to multiple named plaintiffs, or perhaps even rule out injunctive relief in a lawsuit brought by multiple named plaintiffs. That result, which would require separate remedial orders or even separate lawsuits for family members asserting legally and factually identical claims based on joint immigration applications or proceedings, is absurd. There is no conceivable benefit in requiring identical claims to be raised in separate, duplicative actions. This bizarre outcome offers further proof that the court has erred. The ramifications of the court's error should not be ignored. Today's holding risks depriving many vulnerable non-citizens of any meaningful opportunity to protect their rights. To understand why, consider the practical realities of the removal and detention system. Non-citizens subjected to removal proceedings are disproportionately unlikely to be familiar with the U.S. legal system or fluent in the English language. Even so, these individuals must navigate the nation's labyrinth in immigration laws without entitlement to appointed counsel or legal support. If they are detained, like respondents here, they face particularly daunting hurdles. On average, immigration detention facilities are located significantly farther away from detained individuals' communities and court proceedings than criminal jails, making it extraordinarily difficult to secure legal representation. Even for those individuals who can locate and afford counsel under these circumstances, such remote confinement impedes evidence gathering and communication with counsel. After traveling, perhaps for hours, to meet with detained clients, attorneys may be barred from doing so due to logistical or administrative errors. Legal phone calls, too, frequently are non-confidential, prohibitively costly, or otherwise unavailable. Exacerbating these challenges, the government regularly transfers detained non-citizens between facilities, often multiple times. It is one matter to expect non-citizens facing these obstacles to defend against their removal in immigration court. It is another entirely to place upon each of them the added burden of contesting systemic violations of their rights through discrete, collateral, federal court proceedings. In a great many cases, the inevitable consequence of barring class-wide injunctive relief will be that those violations will go unremedied, except as to the few fortunate enough to afford competent collateral counsel or to secure vigorous pro bono representation. The burdens will fall on those least able to vindicate their rights, as well as the law firms and nonprofit organizations that will endeavor to assist as many of these non-citizens as their capacity permits. If, somehow, a substantial number of non-citizens are able to overcome these obstacles and file separate federal lawsuits against unlawful removal or detention policies, a different problem will arise. Class litigation not only enables individual class members to enforce their rights against powerful actors, but also advances judicial economy by eliminating the need for duplicative proceedings pertaining to each class member. In contrast, the court's overbroad reading of Section 1252 F1 forces non-citizens facing unlawful detention, if they are able, to flood district court dockets with individual habeas actions raising materially indistinguishable claims and requesting materially indistinguishable injunctive relief. There is no reason to think Congress intended either of these untenable results. In fairness, the court's decision is not without limits. For instance, The court does not purport to hold that Section 1252 F1 affects courts' ability to hold unlawful and set aside agency action, findings, and conclusions under the Administrative Procedure Act. No such claim is raised here. In addition, the court rightly does not embrace the government's 11th-hour suggestion at oral argument to hold that Section 1252 F1 bars even class-wide declaratory relief, a suggestion that would, if accepted, leave many non-citizens with no practical remedy whatsoever against clear violations by the executive branch. Even with these limits, however, the repercussions of today's decision will be grave. In view of the text and context of Section 1252 F1, these repercussions offer yet more evidence that the court's interpretive effort has gone badly astray. The essence of statutory interpretation is to review the plain meaning of a provision in its context. The court's analysis, by violating several interpretive principles, ultimately fails in that endeavor. I respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. If you would like to support my efforts to make Supreme Court opinions available to the public, please go to the podcast's website. It's at anchor.fm/SCOTUS-opinions/support. Again, the website address is anchor.fm/SCOTUS-opinions/support. There you can also see other episodes and send a message to me, the podcast's creator. Thank you.